Okay, a few people are still joining the meeting, but I think we can start. So, good afternoon and a very warm welcome to everyone. Welcome to today's ECIPE online seminar, in which we want to have a conversation about how online platform regulation and merger policy can impact a country's investability, or in other words, the capacity of a country to remain or become attractive to entrepreneurs, startups, and investors. For quite some time now, we are seeing efforts in Europe, but also in non-European countries to pass new laws that in many ways restrict the behavior of large companies in the digital economy, where the political motivation is to either maintain competition or to curb the alleged abuse of market power. The Digital Markets Act, which was passed for the EU, is considered a prime example by fans of such rules, with many prohibitions, many commandments, and a similar law is now about to be introduced in the United Kingdom, which might give the British competition regulator extensive powers to oversee large companies that provide digital services in the UK, and powers to ban or require them to change certain business practices. There is, for example, clause 19 of the proposed competition bill, which would grant the UK competition regulator extensive authority to enforce conduct regulations on businesses identified by the regulator to hold so-called strategic market status, which will likely be the world's most competitive and innovative technology companies. And when it comes to merger policy, competition policies also often fail to adequately consider efficiency criteria and the resultant benefits for consumers. The proposed acquisition of Activision Blizzard, which is a video game maker by Microsoft, I think is a very important case in point, where the UK competition regulator had initially found that the acquisition would reduce competition in gaming markets. And on the contrary, the EU and US competition regulators have cleared the transaction. And I think this example is already highlighting the uncertain nature, I shall say, legal uncertainty of merger review results for international transactions when digital services or digitally enabled services are involved. In a recent ECIPE analysis, you will find a link to this piece in the chat box. We find that competition policy that is targeted at large technology companies often relies on presumptions rather than evidence of real consumer harm. And at the same time, interventions in digital services markets can have far-reaching consequences for innovation, technology adoption, and also investment. And that is, of course, extremely important, given that governments usually pursue ambitious economic policy objectives, if not, as in the case of the EU and also the UK, aspirations for global economic and technology leadership. Personally, I think that the debate about competition policy approaches is far too narrow, and that the advocates of what I would call aggressive competition policy face far too little headwind from both the academic world and from moderate political parties and all those who believe in evidence-based policy in general. And against this background, today we want to talk about the effects of competition policy and platform regulation on investment attractiveness, and in this context also address impacts on innovation and the development of a jurisdiction's international economic competitiveness. And we have invited 3 policy and industry experts who will address various questions, among them how access to globally traded platform services impact a country's investment attractiveness, generally about the motivation of competition authorities to go after large technology companies. More specifically, we want to talk about tipping, why tipping is viewed as a concern in competition theory, and whether concerns about tipping are actually merited. We also want to talk about killer acquisitions and whether they are, or whether the adverse impacts that are frequently mentioned in the discussion about killer acquisitions are actually backed by empirical evidence. We want to talk about corporate conduct bans and how they could impact investment activities and startup activity. And we also want to talk about alternatives. So basically about the question, what competition watchdogs should really do to protect consumers from unfair competition. We have 3 experts with us today. We have Dirk Auer, who is the director of competition policy at the International Center for Law and Economics. We have Fred de Fossart, who is the head of the British Prosperity Unit at the Gattum Institute. And we have Aurélien Porduès, a professor of competition law and innovation at the George Washington University. I would now like to invite our experts to give short opening statements of about 5 to 10 minutes each. And I will then get back to each of our experts with a few more questions before we open the panel to questions from the audience. And that said, dear audience, please put your questions in the chat box or raise your hands when we approach the final quarter of today's discussion. We will proceed in alphabetical order and start with the interventions with Dirk. So please, Dirk, the floor is yours.
Okay, thank you very much for having me on the panel, Matthias. So I think the right starting place is actually to say, well, what do we mean when we say digital competition regulation? So we've seen bills appear in Europe, of course, the DMA. We've seen them in the UK with the DMCC, and we've seen other initiatives, for example, ICO in the United States. So that didn't make it into law. And one of the questions is, well, what are these bills trying to achieve, and what do they have in common? So obviously, at a very superficial level, what seems clear is that they're all trying to target in some way or another the big US GAFAM firms. So they all, in some way or another, target Facebook or Meta, Apple, Amazon, and Google. But beyond that, it's not sort of clear exactly whether they're trying to do the same thing. So in a study with my colleagues, Lazar Radic and Jeffrey Manny, we actually look at many of the digital competition bills that are being or have been passed around the world. And we think that there are 3 important commonalities between bills. And I think that then these commonalities will help us understand what are the sort of the drawbacks and the trade-offs that these bills entail. So a first big commonality is that, unlike competition law, most of these bills have multiple goals. That is a very big change from competition law. If you think of antitrust as pursuing the singular objective of either maximizing consumer welfare or promoting competition, digital competition regulation is different. So these bills often seek to promote fairness, contestability, or sometimes even other goals like going after fake news, which is the case in Brazil. That is not without problems. So the advantage of having one goal is that you have a way of ranking rules for firms. Firms know that they have to comply with this one goal. When you have multiple goals, it creates legal uncertainty for firms, or it can at least create legal uncertainty, because what maximizes contestability is not always going to be the same behavior that maximizes fairness. And that leaves aside the issue of what do these terms actually mean, because courts will have their work cut out if they are to define fairness. So that's one thing. We see multiple goals. We also see a second really important aspect of these bills, which is redistributing rents between firms. Now, competition law already does this indirectly. So, for example, a competition case, by increasing competition, may mean that surplus gets transferred from firms to consumers. That's fine. What's happening here with digital competition regulations is a little bit different. We see policymakers explicitly deciding that the allocation of rents in and of itself is what intervention is seeking to achieve. So to put it in simple terms, competition intervention, you might say that it only exists, or the rent redistribution only exists when simultaneously output is increased. With these digital competition bills, you could have a rule that says, well, we'll redistribute rents from one firm to another, even though we know that output is not going to be increased as a result, or even though we know that consumer welfare won't be increased as a result. So we see this very specific decision to transfer resources from one firm to another. You sometimes see it with the final offer arbitration mechanisms that are in place for some bills. And you also see it with the access regimes that these bills often include. And then a final important commonality is that, as far as we can tell, all of these bills try and protect competitors explicitly. That's usually not the case on the competition law or antitrust. On the competition law or antitrust, we understand that sometimes rivals are going to exit the market, and that can be a good thing. Under these bills, there's a very explicit desire to make sure that firms at the edge of large platforms can remain on the market. This may be a problem because, as sort of any competition law student has heard, the result of competition, when it goes well, is that some firms are going to exit the market. And with these bills, we may have authorities interfering with what is the efficient outcome for a given market. So those are sort of the broad, I think the broad commonalities between these pieces of legislation. But after that, we start to see some differences, and these differences can create different challenges in different jurisdictions. So, for example, a useful comparison is going to be between something like the DMCC in the UK and the DMA in Europe. And I'll try and be brief so I don't go over my time. But the very basic, you can think of the DMCC and the DMA as pursuing these three objectives that I mentioned, but with a diametrically opposed strategy. So the DMCC bill, on the one hand, is defined in a very, very broad way. The CMA has very broad powers under the bill, and that could be a good thing, because it could mean that the CMA and the bill create flexibility to go after behavior that hasn't been foreseen now. Unfortunately, in the case of the DMA, that broadness is not accompanied by a very strict standard of judicial review. It's actually what's called judicial review in the UK, but it means courts ultimately have very little oversight over this very broad bill. That can create a series of problems, obviously, for companies who may feel that they have very little power to argue against what the regulator is saying, and very little power to put forward efficiencies. So that's the DMCC model, and I think those are the important flaws. At the other extreme, you could have something like the DMA, which is extremely specified. The DMA, compared to the DMCC, writes rules black on white, very precisely, but that generates problems too. The same rules apply to all companies, and the rules are strictly defined. So sometimes a rule may not make sense for a company. It may be obvious to everyone that it harms consumers, but it could be enforced anyway. And so there's very little leeway when it comes to the DMA. That being said, the upside is that because the rules are written very precisely, companies at least have some level of legal certainty as to what ultimately they will need to comply with. So same goals, different types of legislation. And at the end, the question is, well, what will be the result of these bills? And I think in both cases, both the DMCC and the DMA case, the shortcomings that I have mentioned could end up being a problem. So in the DMCC case, we've already seen some CMA decisions that have not been well received by industry. Microsoft, Activision, Blizzard, the first rejection is one example or Meta Giphy is another one. And there's a risk that it could deter tech investments in the United Kingdom. If you look at the DMA, I think there have to be fears that the bill may end up being too rigid and that we will disincentivize firms from improving their platforms in ways that would otherwise benefit consumers. So I think there are important pitfalls to these bills, and whatever reasonable people can disagree whether we should have digital market regulation or not. But at the end of the day, I don't think either of those two models is optimal, and I think there's room for improvement. And I'll stop there for the moment.
Yeah, thank you, Dirk, for the introduction, which was already quite comprehensive. I've made a few notes. I will come back to the goals that you just mentioned, but also the legal certainty that we see arriving from these regulations in the UK, but also the EU in a minute. Let's proceed with Fred. Fred, the floor is yours.
Thank you very much, Matthias, and thank you, Dirk, for your introduction to the two approaches in Europe and in the UK. By way of introduction, I run the British Prosperity Unit at the Garton Institute in London. Before that, I worked in the British government and the Conservative Party for about 3 years. I advised a minister called Jacob Rees-Mogg through multiple roles, and this is how I came into contact with the Digital Markets Bill when he was in the Cabinet Office and as Business Secretary. I became a little bit of a professional menace when it came to this bill, because I was one of a small group of people in government that realised the unintended consequences for British competitiveness, the investment and dynamism in the British economy. We made some headway with trying to delay the bill and get rid of some of its worst aspects, but alas, once I left government, as did Mr. Rees-Mogg, the bill has made its way through Parliament. It was originally meant to be published in draft form, for those that don't know. That would have been very helpful because we would have been able to ensure that MPs and members of the House of Lords were able to really pore over all of the problems with the bill that is very aware to everyone in this group. But instead the bill has been introduced through immediate legislation. This is a shame because it's steamrolled its way through the House of Commons so far with very little scrutiny. And because I think it's picked a rather convenient political enemy, i.e. the global tech giants, largely American tech giants, it hasn't received the amount of scrutiny that it deserves. From a political point of view about Brexit and even the European Union, from my point of view, it is quite an extraordinary move to decide to leave the European Union and the single market, and then introduce a potentially even more aggressive and deterring and uncompetitive regulatory environment for the digital economy. I would have thought that the sensible way to do this would be to leave the European Union and try and find a more welcoming, deregulatory, competitive environment which welcomes investment. But alas, the British government is not doing that. That is a real shame. As we know already, the bill will allow the CMA to redesign tech products, demand pre-approval for the launch of new products by designated firms, which they claim could be used to entrench their market position, and even levy fines worth 10% of a company's global turnover. And all of this will be done with reduced accountability, both legal and democratic. Dirk has touched on the legal issues, but I think the lack of democratic accountability is just as important as well. One of the big philosophical arguments in Britain is about where power lies. Does it lie with Parliament? Does it lie with regulators? Does it lie with the European Union? Does it lie with the courts? We all thought that power was meant to lie with Parliament, who is made up of elected lawmakers. But instead, this bill is about to hand huge powers away from Parliament, ministers, and to a regulator. Instead, it changes the nature of the CMA as well. The CMA until recently was, as one person described, a rather narrowly focused antitrust enforcement agency whose focus was maximising consumer welfare. By turning the CMA into a digital markets regulator, it becomes an ex-ante regulator akin to Ofcom or Ofwat, which regulate utilities. This fundamentally alters the way the CMA works, and as I said already, it has been happening with very little political scrutiny. Interestingly, the CMA has not been using the powers it already has very well. Dirk has just mentioned the case of Microsoft and Activision. I would also like to add the issue of the CMA's attempt to block Amazon's investment in Deliveroo. The CMA right now is claiming it needs even more powers to try and block these sorts of investments which would benefit big tech companies. Yet in 2020, it already had enough power to try and block Amazon's investment in Deliveroo. This was a very, very interesting moment for the CMA because at the start of the pandemic, there was all manner of economic uncertainty. We did not know whether Deliveroo, a British tech company, was going to survive or was going to go bust. And unsurprisingly, they were very keen to have investment from one of the largest companies in the world, Amazon, with great expertise in online delivery. Yet the CMA decided that was a bad thing. The CMA eventually wrote back, but it did show their intentions, and it should be a warning sign to anyone that wants to give these sorts of powers without accountability to the CMA. Matthias mentioned to me beforehand the concept of power without accountability that George Perez, KC, the lawyer, has been talking about. And I think this is one of the things which we hope we can form a sort of coalition of people around which we can amend this bill. This bill has passed its stages in the House of Commons. It is going to make its way into the House of Lords, where hopefully we will be able to see another round of amendments to it. The government actually tabled 200 amendments to the bill, which was quite remarkable in its own way, but the vast majority of these amendments were very small and very technical. Some of them have increased accountability, some of them have introduced rules which might fetter some of the digital market units and the CMA's powers, but overall the bill remains the same shape. The House of Lords will be very interesting because we will be able to, or we hope, that organisations like Legatum and everyone on this call will be able to persuade members of the House of Lords that in the interest of good governance and good regulation, high evidence standards are going to be essential for making sure this regulatory environment is sustainable. I think a lot of us know that we are well past the point of arguing that this bill should not happen at all, that the digital markets unit should not be established. Instead, we're now in the territory of working out it's going to be established in the best possible way. And also, we're really going to overturn the fundamental principle that has guided antitrust policy in the whole West for the last 30 years, that consumer benefit is paramount. Then we need to make sure that the powers that we have in the CMA are properly accountable and properly managed. There seems to be, the CMA is not acknowledging a fundamental trade-off when it comes to power and accountability. In my view, if you want greater powers, then you have to have greater legal accountability. But if you want to levy a fine worth 10% of a company's global turnover and redesign the way they do their products, it seems only fair for that company to be able to have its day in court. However, if you don't want them to have their day in court and only want to be able to challenge it on process grounds, it seems only logical that the powers they do have should be reduced. This, I think, is a hopefully important and principles logical argument which we'll try and land over the next few months as this bill goes through the House of Lords, but we will see. The jury is out for now, but we may make some progress. It has had an interesting range of backers in the UK as well. Some of you will know about an organisation called the Coalition of App Fairness. Spotify are one of their biggest supporters. And it makes me think of one of the things Dirk said earlier about the distribution of revs. We're entering into a very interesting territory where the government has essentially decided that it likes medium-sized tech companies and it doesn't like big American tech companies. Therefore, it is designing a regulatory regime to benefit medium-sized tech companies. And consumers are unfortunately becoming a secondary concern here. What I would say is that companies like Spotify could well be dicing with death here, because Spotify is one of the biggest advocates of this bill. However, Spotify is an absolute behemoth within the streaming market. So I think it's very strange that Spotify thinks that this regulatory regime won't bite them in the future. Because if you look at the way the bill is designed, and this is one of the big problems with it, the designation thresholds, the definitions are so loosely designed. So there is so little accountability and so few checks and balances that would stop the CMA from changing these thresholds that any company like Spotify could find itself regulated by this bill in the near future. Spotify's turnover threshold globally and in the UK aren't high enough yet for them to qualify within the regime. But then the CMA may decide to open investigations into the streaming market and determine that they actually have strategic market status in the streaming market because of their dominance in there. The CMA has a habit of creating new categories, which I think which consumers don't agree with. The Microsoft Activision case is a very interesting example because they claim that would cause a lack of competition in the sector of cloud gaming. Cloud gaming, I don't think exists as a sector. The sector should be considered gaming as a whole. Cloud gaming is just one delivery mechanism for wider gaming, which can compete with consoles and other forms of gaming. Instead, the CMA chose to find a narrower and narrower route to determine that someone has a monopoly and then regulate accordingly. To me, it sets a very worrying precedent that the CMA is essentially trying to challenge innovators that may have temporary monopolies, and almost it could almost do away with the whole point of intellectual property protection. So, in summary, before we move on to questions, and Aurelian, I think that we have a window of opportunity to continue to amend this bill. We need to ensure that due process and good governance and high levels of accountability are embedded in this regulation, and remind the CMA that they should not fear high evidence standards. It should not fear getting its decisions right. And they should always remember this trade-off between power and accountability. And all politicians, both left and right, should think very carefully before they hand away these sorts of powers from the democratic to the appointed. Thank you very much.
Thank you very much, Fred. That was also a very, very rich introductory statement. I'll come back to a few issues in a minute.
Right.
Before we do that, let us get to Aurelian. Aurelian, perhaps you could also elaborate a bit on mergers and acquisitions and different approaches of regulators and how they could potentially impact investment activity. Also, giving us a bit of a US perspective on things.
Correct. Thank you very much, Matthias, for having me. It's a great pleasure to be back. So I just want to focus perhaps on competitiveness and why concerns for competitiveness may justify good or at least clear merger guidelines if we want to increase competitiveness. So competitiveness is a very important aspect in the global competition of nations. It's made of three things, mostly the product and service market. Also, we have mobile factors, production factors, such as the capital and investments, and more immobile factors, such as labor. And competitiveness is all about precisely these mobile factors, which is about capital, how to attract capital into a country and to increase the capital density of an economy through increased technology. And so the assertive merger policy can deter capital investment from abroad because it just it created a tax and it increased the uncertainty for investors to get out if they need to pull up the capital that they've invested. Also, it really deter to increase merger assertiveness, it really deter productivity gains in the sense that it lowers the risks for hostile takeover, right? The lower capital you have, the slower the market for corporate control is. So companies become more entrenched and more protected in their market shares. And this protection in these market shares just doesn't challenge them or doesn't generate risks for those companies to increase productivity or to have the fear of being taken over or to lack competitiveness internally. And these internal decrease of productivity also impact, of course, the international competitiveness. And finally, the lack of investment from abroad that scales the economy in order to enter new markets, because you cannot have the capital enough for companies domestically to gain scales domestically in order to grow and buy one each other in order to enter new markets externally. And that is something very, very problematic if you consider that entering new market is part of the innovation process. And I think it is. We have to have these large scale company, or at least these startups that can scale up in order to enter new markets. So the overall effect of increased merger assertiveness by changing the policy or changing the law, lower the productivity generally, and lower and shrink the market for corporate control, right? You have fewer companies to buy, and the companies that are there are not to be bought by foreign competitors or even by domestic competitors, because the market becomes ossified. And these ossifications lower the productivity, and this productivity is deterring, is worsening the balance of trade and of the nation in general. And yet, so we have collaborations between assets is imperative, right? So companies needs to have some collaborations, needs to have some complementarities. But in a regulatory framework where mergers becomes nearly impossible, because of very strong assertive policy, and we see it with the draft merger guidelines in the US, where basically the only guidelines you can get from those 13 guidelines is do not merge, or it's like do not merge because there's a major risks. So in a regulatory environment where you're told not to merge, and yet you need those complementary assets that you cannot build, or you may build, but it may take many more years for you to generate the product and bring it to the consumers. How do you create those collaborations? Well, the paradox of having an assertive merger policy, or as a very strong stance against mergers, is to potentially incentivize vertical and horizontal restraints. These kind of contracts, because you cannot merge, you cannot have the 51% of the corporate assets. It may increase also some horizontal and vertical restraints by creating those complementarities that you have. Or you may not have those vertical or horizontal restraints, but you just don't buy the company, and you buy the talent and the resources. And I think this weekend, what Microsoft may have done over OpenAI is a quite good example of this kind of acquire hire, where you don't acquire the company because of many aspects, and regulatory risks and antitrust risks is one of them. But you acquire the talent because most of those tech companies, the value is made out of the human resources. I mean, of course, there's the digital infrastructure that cannot be ignored, and I think that's one of the great Microsoft computational power is precisely one of the benefits of the collaboration between OpenAI and Microsoft. But the main value is through the human resources. So what I'm saying is that by prohibiting those mergers, companies need to collaborate, and they're going to find ways to collaborate, because you cannot stop collaborations, you cannot stop transactions and partnerships, just contractual partnerships. And one of those partnerships is with human resources, with talents. So that's why we may see also some effect on the labor, or at least not a very dynamic market for corporate control, but a more dynamic market for something else, which is like a second best choice solution, which is vertical restraints or acquire hire. So and I mean, with the case of Microsoft and OpenAI that we just saw over the weekend, is that the paradox is that too much regulatory scrutiny on mergers kills regulatory scrutiny. Just the left curve. Like, companies going to find ways to avoid merger reviews because they don't want to go to merger reviews. They know it's going to be blocked. Therefore, they're going to do all the partnerships, joint ventures, acquire hires, vertical or horizontal restraints, which may be completely under the radar. So what I'm trying to say is, for those who want very strong, assertive merger policy, it may be even counterproductive for their own goal to do that, because they may see fewer deals. They may have, they can detect fewer deals. So I think the solution is to care about competitiveness and to have a very reasonable merger policy, that, as Doug said, rests on good consumer welfare standard, or that really can focus on traditional tools. And I'm even for simplifying it, right? Not increasing the time of closing the deal. That's what we're doing now in the US. You used to close a deal in a couple of months. Now it's 6 or 1 year. And of course, you anticipate some litigations, which may take many years. That's the worst for the business environments and for competitiveness, because you increase the legal uncertainty. And that legal uncertainty is a tax. The tax is the legal fees that you have to pay to the lawyers, and the seller, the startup, gonna internalize those legal fees, and as a decreased price for its valuation of this company, right? It's basically it harms more the acquiree than the acquirer to have like increased legal fees that the acquirer gonna pay, because the acquirer gonna pass on those legal fees and this increased regulatory uncertainty onto the acquiree. So it's a tax for startups. So that's something that is bad for the competitiveness of the nation, but it's not just so bad for small startup companies and entrepreneurs. So what we need is just a reasonable approach to merger policy with, I'm even for presumptions or even reverse burden of proof if you want to shorten up like a structured rule of reason when we talk about mergers. I'm open to discuss like how can we improve the tools that we already have, but when it comes to U.S. policy, U.S. merger guidelines, we should have definitely have built upon 2010 and 2020 merger guidelines. We shouldn't have just like get rid of them and just change the framework. There's always ways of improvement, of course, but these should be interactive discussions with stakeholders, scholars, the industry, in order to improve merger guidelines, not to just say, let's do a U-turn that no matter what, the courts won't follow. And that's also another aspect that I haven't emphasized, but there's an increased regulatory uncertainty because we don't know what the guidelines mean, but also we know that the courts won't follow it. So who to follow, the agencies or the courts? And that's the worst for the business environment. The greatest assertiveness against mergers without regulatory certainty, or at least clarity. So I think it's a lose-lose situation for, at least in the US, the Brandesians regulators who want increased assertiveness, because I think they will have fewer deals being referred and being reviewed by the agencies, because companies can find other ways than mergers to control assets, right? We saw that over the weekend, and it's a lose situation for business and for innovation, because at the end of the day, the benefits of mergers won't be ripped out, but they will be ripped out by second best choice solutions, which are some sort of partnerships or vertical or horizontal restraints or acquire that are not as ideal as mergers in order to integrate product and services and to get a throughput process from an innovation to consumers.
Yeah, very good, Oriane. To follow up on this, and I would also like to encourage our audience, if you have any questions, please put them in the chat box and we'll get back to your question in a minute. Oriane, just a follow-up question. I mean, you mentioned that there's now a trend towards more regulatory scrutiny, which will effectively lead to less regulatory scrutiny because companies try to avoid below the radar. And they have the means and also the resources to do so, I suppose. Looking at it from a bird's eye perspective, from economic theory kind of perspective, do we need a mindset change, not only on the side of regulators, but also in academic circles when it comes to developing and relying on the right theories underlying, competition enforcement that we see in the United States, but also in other jurisdictions like in Europe?
Yeah. I think it's all the dynamism of the market leads to challenge and to rethink how we define market. The core is market definition. When we want to make every company look like a monopoly, I think it's easy to block those mergers. I think we need to understand that those markets are highly dynamic, and the spendings on research and development by those companies demonstrate their way out of competition through innovation. So they try to compete by creating niche markets, and those niche markets, I think it's not leading to some monopolizations, or I think it's the start of a new market. And the idea that a company, we have to block the merger because this company has created a niche market and now it's over, the market's over. No, I think it's flowing in. It's just attracting more startups in that market. So I think the way we need to think about it, if we really care about innovation and the dynamism of this of those industries and markets, is to look at how the market that we defined are really not market, but should be more cluster, or should be a sort of ecosystem where the competitive constraints are from primary source, like basically your primary market, but from adjacent source and from secondary source, where you can see that these new competitors really have some freedom to come and compete. The idea that you just mentioned, also the market tipping, that's a very good idea, is that you create a market, you tip the market, but it's the creation of the market, it's also the innovation. And so you need to have, just like as the patent system, you need to have some time in order to recoup the return on your investments. And if we don't create those very temporary tipping situation, then there wouldn't be entry at all. So I think we need to understand that the tipping of the market, which is a very bad way of putting it, because it's not a tipping of a market, it's a creation of a niche market. The creation of the niche market will also attract new startups, and it should attract new startups. Then if the company has done as doing some predatory and anti-competitive behavior, yes, of course, we should be cautious and we should have regulatory scrutiny over those behaviors. But we shouldn't block the merger up front, saying that no innovation will ever take place in this niche market that we don't even know and has just been created. It's very unfortunate. I remember a couple of years ago, when the European Commission opened the sector scrutiny on the Internet of Things. They're saying like, oh, that's it. The Internet of Things, the virtual assistant. This is the market that has already tipped, and that's it. There won't be any innovation on virtual assistant. And the three main companies like Amazon, Google, that's it. They've monopolized the market. It's already monopolistic, and the market is tipped, so there's no virtual assistant. That's why precisely the virtual assistant is inside the Digital Market Act, because there's a lot of people who really believe that it's monopolized. And then we have, of course, all the ChatGPT, where you interact vocally with the ChatGPT, all AI, where all these interactions is vocal. So what I'm saying is this niche market was not about to be monopolized, but was just the first mover advantage that those those companies had, but they had to have some advantage. If you're a first mover disadvantage, well, you're not first mover at all. So I think we need to think more carefully about market definition when it comes to mergers, and the idea that this market has been monopolized, I think it's misguided, unfortunately.
Yeah, thanks a lot. Dirk, you mentioned at the very beginning that there's differences in motivations for policymakers when it comes to enacting platform regulation, behavioral conduct rules on large technology companies, ranging from fairness, which is already a very, very broad term, contestability, which is also, in my view, a very broad and inappropriate term to focus on from the perspective of competition regulators. And then there are other objectives like distributing rents, allowing others to enter a market on the basis of certain regulations. Now, I wonder whether all of these objectives are actually consistent. When we thought about this in our work on competition, we came to the very broad conclusion, well, it's a simple conclusion, that all competition theory is gray. And it appears when you look at gatekeeper regulation in the EU, the competition bill in the UK, that in a way the threshold levels are taken out of the blue. When you look at merger reviews, different authorities are coming to different conclusions. And I wonder, and this is my question to you, Dirk, whether all of these differences in goals, but also the potential inconsistencies in the objectives of policymakers are accounted for in the impact assessments. Yeah. So after all, I mean, the UK, but also the EU is committed to better regulation, to proportionality, to solid impact assessments in accordance to OECD good regulatory design. But what do you know about the quality of the impact assessment? Also, when we look at what's currently in the making in the UK.
Okay, so I think that raises a couple of things. I see sort of 3 points. One is vagueness, the other one is arbitrariness, and the third one is impact assessments. So on vagueness, I actually don't worry as much as some other sort of skeptics of these bills. My problem isn't with, so what do I mean when I say that? You could say that competition or antitrust law, if you read the law, it's extremely broad. The thing is that courts have been given the power to flesh out those very broad terms, like what does a restraint of trade mean? What is a restriction of competition? Courts have spent decades with both the power to review that and the time to sort of look at different cases and flesh out what it means. My fear is that when we talk about these digital market regulations, the time isn't there. If I go and say to Didier Reynders or Thierry Breton tomorrow, look, it's fine, the DMA in 20, 30 years will understand what it actually means, I don't think they'll be very satisfied. So I think that digital markets regulations are likely to not fulfill expectations on that front, or not fulfill the expectations of their backers. So that's one vagueness. You mentioned arbitrariness. I think that's another issue. And we sort of see it now with the DMA designation decisions. We have these thresholds, and someone could be forgiven for reading the bill and saying, yeah, it makes sense to me. If a company makes X billion euros, that must mean it's got market power. But anyone who studied competition law knows that reality is often more complicated. So you have many firms that have very high revenue, but it's because they take a very small margin in many big markets. That doesn't necessarily mean market power. It can be a very competitive situation. There's clearly a desire with these digital market regulations to sort of cut the Gordian knot and say, well, we don't really worry too much, and this is the law of the land now. I don't know. I don't think that will play out exactly like backers hope, because you already see that with, for example, TikTok's appeal, or at least appeal to its designation decision, or at least sort of the debates that took place within that designation decision. Sort of TikTok saying, look, we've just arrived on this market. We're still a growing company. Who's to say that another firm isn't going to overthrow us tomorrow? And so you may have these very strange situations where TikTok has one hand tied behind its back, and a competitor that's up and coming could overthrow them. I don't know that that's necessarily good for consumers. I don't think, on the competition law at least, that we think it's a good idea to sort of kneecap one firm so rivals can overtake it. And then the last point is on impact assessments. And there, I'm not the greatest expert on impact assessments, but it does seem to me that when you look at how these bills were passed or are being passed into law, especially in Europe, there seems to have been a thumb on the scale. There was tremendous political desire to get these bills passed. And some might say, well, the impact assessment was done properly. I think it's hard to do an impact assessment properly when you have such political pressure to get something done. And I struggle to imagine what would have happened if the impact assessments had shown that these bills were harmful to consumers. And sort of going from there, I think it's unlikely that an impact assessment would have come to that conclusion in the first place. So those are my thoughts on your questions.
Thank you very much. I must admit they are very much in line with what I observe. So the quality of the impact assessment, especially for the DMA, is fairly poor, to say the least. Adherence to the consumer standards in EU and also national EU member state competition policy, I think it could be improved.
Yeah, I will say that in the UK, there seems to be more debate for the moment, and there seems to be right now in this moment a real reckoning, or sort of focusing on, well, what are the trade-offs of these bills, and we'll see where things land. But at the very least, the process seems a little bit more open-ended than it was in the European Union.
Yeah, and I would like to get back to this now, asking you, Fred, about the state in the UK. I mean, are you happy with the impact assessment that was done by the responsible department? You mentioned that, if I understood it correctly, we should not have the new UK competition bill in the first place. But now that it has made its way through the institutions, and if I understand it correctly, it's now with the House of Lords to decide. What would be your wish list in terms of amendments, also taking into considerations the potential impacts on investments in a country that, compared to the United States or the European Union's single market, has much less economic gravity?
Yeah, thank you, Matthias. Impact assessments in the British government are pretty bad by and large. This has been an open secret for some time, but it has become a bit more of a political issue since the pandemic. I think because the government was producing very, very shoddy impact assessments about the economic effect of pandemic regulations. This became an increasingly controversial issue as the pandemic wore on, as new restrictions were introduced and the impact assessments were either delivered to Parliament late or not at all, or they were very, very bad quality. So actually, it's quite useful that this has opened up a political debate about the use of these impact assessments. The impact assessment for this bill, the DMCC, I think is very bad. I think, as Dirk and you just mentioned, like, the things were very much on the scale with the DMCC impact assessment. And I have to say, I can guarantee that the ministers sponsoring the bill will not have read the impact assessment. The actual approval process for these impact assessment, in the way it works in the British government, is unfortunately very lacking. What I would like to see is maybe the same quality of impact assessments they have in the Congressional Budget Office in the United States, but that is quite a serious. That the CBO works in the American context. In the legislature, whereas our impact assessments are all done internally by the government. So there's a structural difference there which doesn't quite match up, but I think it's something we should consider, because the impact assessments done in America, particularly the use of dynamic assessment and dynamic modelling, are much better than the very static impact assessments that are done in the UK. To the wish list for the bill. So yeah, the House of Lords typically look at the legislation much more detailed than the House of Commons. The House of Commons do the broad brush political notes, and the House of Lords go right into the technicalities. And this is the opportunity for quite serious improvements to the bill. One thing I would really like to see would be things like making sure that every time the CMA does an investigation into a strategic market status company, that the investigation is bound by a specific terms of reference. If we don't have the terms of reference, then they can go on fishing expeditions and investigate anything they want in the company. If we put a binding terms of reference, which links back to the original reason for the investigation, then we're able to narrow their investigations massively and reduce the likelihood of regulatory overreach. In my earlier talk, I mentioned definitions. So turnover threshold is one of the definitions for a strategic market status firm. At the moment, it's either 1 billion UK turnover or 25 billion global turnover. That is obviously far too loose. You should make it both, so you have to have 1 billion UK and 25 billion global. That all of a sudden will massively reduce the scope of this bill and will limit it just to the largest tech companies. So and I have obviously a much longer list of these sorts of measures, but if you think about it like that, it's going to be those kind of measures that tighten up some of the areas and get rid of the ambiguity or the loose bits of drafting, which would help. And I think that those are the sort of things that would appeal to the House of Lords. On competitiveness and investment, what you said actually makes me think of the really good points that Aurelia made around competitiveness, investment and regulation earlier. I think the problem with this bill around competitiveness and investment is that we've decided to regulate symptoms instead of understand big structural causes and go back on the first principles about what is creating the lack of British competitiveness in the economy at the moment. institutional investment from pension funds and businesses in Britain is very bad and has been for a very long time. So if you're an innovative startup and you want investment, you either get it from venture capital or you might get it from big tech. And big tech have provided huge amounts of investment to the British startup ecosystem. Look at Google's investment in DeepMind. It has been one of the most brilliant investments in tech ever. And it's led to the development of a brilliant ecosystem of startups and talent in the UK. And the UK economy has benefited massively from Google's investment in DeepMind. However, this is politically quite contentious because there's a movement in British politics that think overseas investment and overseas mergers are bad. Partly for national security reasons, but also for this whole idea that we don't like American tech companies buying up British tech companies. But just as what Aurelian was talking about, the unintended consequences of heavy regulation on mergers leads to unintended consequences like the OpenAI on Microsoft issue, which is so interesting. I bet will happen more. We're seeing very similar issues. We're going to see very similar issues here. And it's a little bit like the Laffer curve with taxation. You set it too high and then all of a sudden people try and find ways of dodging around it. And I think that this bill will probably do similar things like that. But ultimately, Britain will lose, and Europe will probably lose as well, and the winner will still be the United States, because British entrepreneurs will move to America, as they already are, but more and more of them will move to America. European entrepreneurs will move to America, and Google, Amazon will be able to invest in American startups, and then eventually British consumers will get the products, but much later than we might otherwise would have done. So I think on the investment and competitiveness side of things, it's very bad, and there's a lot of a misunderstanding about the mergers policy in this bill. A lot of people think that this bill isn't going to touch mergers because there was a big public U-turn about a year ago after an outcry from the startup and the VC community. Unfortunately, many of the bad restrictions on mergers are still in this bill. And it includes things like mandatory notification of any acquisition or purchase worth £25 million. And these mandatory notifications are going to be expensive, they're going to be costly, they're going to be time consuming. So if you're in that position to buy an AI company that does one consumer-related technology in London, or an AI company that does consumer-related technology in New York, you'll probably buy the one in America because it's just easier. And then in the end, Britain loses out on more investment.
Yeah, that's right. So yeah, thanks a lot for this overview and also for outlining a few ideas for amendments that, against the background of what we just discussed, impacts of investments in particular, seem to be quite crucial. Now we were running out of time. I think we could continue talking about hours and hours about the file, but let's come to a close. And I would like to close with a somewhat provocative question, but also I think a question that that is relevant, given that I feel, and I think that's also true for others, that competition policy, competition enforcement in many ways is like a hydra, where you try to solve one problem, but at the same time create more problems than you initially solved. So my somewhat provocative question to close our session today: do we still need competition authorities? And if so, what should competition watchdogs do to protect consumers from what often is called unfair competition? Starting with Dirk.
So I think if you want to protect consumers from unfair competition, it may be sort of uncontroversial, but you want to get decisions right. You want to allocate the right amount of resources to the case you're bringing to make sure that you don't get those cases you bring wrong. And hopefully then, by bringing those cases, and when consumers are harmed, sanctioning firms appropriately, you will have deterrence, and hopefully good conduct does not get deterred and harmful conduct gets punished and is deterred. That's I think what you hope. That's the best outcome. And I'm not sure that we're going to achieve this with the DMCC and the DMA.
Okay, thanks a lot. So I hear case-specific analysis and deterrence. Aurelian, what do you suggest?
Oh yeah. Do we need competition agencies? I think more than ever. Why? Because I mean, you've heard also some ideas about creating a digital regulator and stuff like that. I think that's even way worse than we can do. So I think we can do a lot with traditional tools. There's no like such a thing like a digital market. The offline and online market are totally intertwined. So we don't need a digital regulator. We just need regulators that take the whole market as it is. And so those ideas of creating a digital regulator that will leave totally the offline economy untouched and regulate those digital, I think it's just completely misguided. So we need a competition agencies that takes offline and online markets comprehensively, because the competition takes place between those two modes of distributions. These are not market, they are modes of distributions. Second of all, what about cartels? I mean, we always talk about unilateral conduct. I mean, we've seen a decrease in the way we detect cartels. We've seen a decrease in enforcement against cartels. And I think those cartels are the most egregious practices that harm consumers every single day. So I think we need more of coordination and more between competition agencies internationally in terms of information exchanges in order to detect cartels or to improve whistleblower policies and leniencies policies that work. And we have decades of practices about that. And yet there's nothing that's really done seriously against cartels. Third, I mean, if we think about competition agencies as working hand in hand with consumer protections harms, I think, yes, we need consumer protection in the sense that unfair method of competition, meaning deceptive practices, lying and stealing IP or these things like that, needs to be strongly enforced. You cannot compete by disparaging or stealing IP, violating trademarks, impersonating. These are unfair methods of competition. So we should just, this is also the more civil, but also the criminal part. Like, we should be very strong about those practices. But on mergers, we should have better tools and more reasonable approach. But on competition agencies are needed more than ever, and we don't need more regulators, like specific sector-specific regulators. I think competition agencies are the general purpose. It's not general AI, but it's at least general purpose competition agencies that we still need.
Yeah, very good. There was a lot of inspiration too. First of all, don't carve out a digital from the rest of the economy. The lines are blurred. Brad, what would be your conclusion?
Well, Dirk and Greg have given so many ideas. I'm going to pick somewhere in between the two of them, I hate to say. I think to operate the best interest of the consumers, the CMA in Britain needs to proudly and publicly hold itself to the highest possible evidence standards and make sure that those evidence standards are known to the public, that they are clear, and that they are enforced even-handedly, regardless of what sort of type of company you are, regardless of your size, and that they should be more accountable to Parliament and democracy.
Very good. I think I could not agree more. The theory of competition theory is great, and it can be exploited by political appetite, for, as we see in the EU, for bold industrial policy and protection of certain industry incumbents. Yeah, that said, I would like to express my gratitude to all of you, our distinguished panelists. I think all of your views, your expertise has in many ways illuminated the path towards effective competition policy. Effective competition policy is obviously not what we see these days, but there's hope that things will improve in the future. And I think we all appreciate your ongoing commitment to fostering what I would call much more informed debate in this important policy domain. So again, thank you very much. Let us keep in touch, and all the best for your future work. Thanks a lot.
Thank you very much.